The African Court of Human and People's Rights was established by the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, which entered into force in 2004. It is a regional court created to make judgments on African Union states' compliance with the African Charter on Human and People's Rights. It came into being on January 25, 2004 with the ratification by 15 member states of the Court Protocol. To date, 29 of the African Union's 54 members have ratified and are parties to the Court. The OAU discourages prosecution of human rights abuses in the International Criminal Court, hoping that they would be tried by the AFCHPR instead, but the AFCHPR has achieved very little. Functions: collect documents and undertake studies and researches on human and people's rights matters in Africa. Lay down rules aimed at solving the legal problems relating to human and people's rights. Ensure protection of human and people's rights, and interpret all the provisions of the Charter. Location: the court is located in Arusha, Tanzania, at the Phase 2 of the Mwalimu Julius Nyerere Conservation Center complex along Dodoma Road. Election of judges. On January 22, 2006, the 8th Ordinary Session of the Executive Council of the African Union elected the first 11 judges of the African Court on Human and People's Rights. Judges are normally elected for 6-year terms and can be re-elected once. The President and Vice President are elected to 2-year terms and can be re-elected once. The court had its first ordinary session from July 2 to 5, 2006 in Banjul, The Gambia. Jurisdiction: the court has jurisdiction to determine applications against state parties of the Court Protocol. To date, 29 states have ratified the protocol: Algeria, Benin, Burkina Faso, Burundi, Côte d'Ivoire, Comoros, Congo, Gabon, the Gambia, Ghana, Kenya, Libya, Lesotho, Malawi, Mali, Mauritania, Mauritius, Mozambique, Nigeria, Niger, Uganda, Rwanda, Arab Sahrawi Republic, Senegal, South Africa, Tanzania, Togo and Tunisia. An application against these states may be made by the African Commission or African intergovernmental organizations, where a state has made a declaration accepting the right of individual application. An individual or NGO with observer status before the African Commission on Human and People's Rights may make an application. 7 states have made the declaration: Burkina Faso, Côte d'Ivoire, Ghana, Malawi, Mali, Rwanda and Tanzania. Judgments: on December 15, 2009, the court delivered its first judgment, finding an application against Senegal inadmissible. The court's first judgment on the merits of a case was issued on June 14, 2013, in a case involving Tanzania. It found Tanzania had violated its citizens' rights to freely participate in government directly or through representatives regardless of their party affiliation, and ordered Tanzania to take constitutional, legislative, and all other measures necessary to remedy these violations. On March 28, 2014, the court ruled against Burkina Faso, in a case brought by the family of Norbert Zongo, a newspaper editor who was murdered in 1998. The court found that Burkina Faso had failed to properly investigate the murder, and had failed in its obligations to protect journalists. Composition of the court: former judges.